On the other hand, adversarial judges fairly reopen the arguments whenever a new point of law or fact occurs in their minds, give opportunities to both the counsel to argue on those points and then only give a decision. They never shock the parties by surprising them. They never hit their ships with torpedoes of their own equities or ideas of dharma. So, a torpedo, when there is war, a torpedo attack takes place by sending a torpedo. It's nothing but a bomb which travels below the surface and hits the ship. Suddenly, what happened? The ship has sunk. The same. In the higher judiciary, predictability of judgments might become slightly less, as there is a possibility of a larger bench overruling smaller benches ruling. The higher judiciary is like a railway track laying and repairing machine, which can be seen in the illustrative video. Such occasions arise rarely, but even here, if the higher judiciary applies the principle of prospective overruling of well established citations, it would go a long way in preserving predictability. Same thing happens when the inquisitorial judge decides cases, sitting as an adversarial judge. No doubt, these unconventional views. Law is predominantly like a railway track and not just a guideline. The mandatory provisions and binding precedents which interpret the law, forming the flesh and blood around the skeleton, are similar to railway tracks to bind the judicial train to travel only on the track. A lawyer, in his capacity as a railway map reader of the tracks, can guide the public to decide whether a track is available to reach the destination by train, and if so, which train is to be boarded and at what cost, and the probable time it might take to reach the destination. The Honorable Mr. Justice M.N. Venkatachalaya, former Chief Justice of India, was gracious enough to write the foreword to my book. I am only extracting some portions of it to tell my audience. The success rate of some lawyers might be high, as they filter out bad cases at the threshold and accumulate only good briefs. What's wrong with this? He only decides as a referee which of the litigating parties have correctly played the game prior to their entry into court. When I say judge is a referee, I am not trivializing his role, but only trying to show the well-intended limitations of his office. A trial in a law court is not just a match between two lawyers. This is also important. Lawyers also should realize that their success is on account of the inherent strength or weakness. Their failure also is due to the inherent weakness of their clients' cases. Their job is to skillfully identify and polish the case, as if just as a diamond cutter and polisher, he polishes a true diamond so that it will shine. So only the lawyers with good professional competence can do that. Competence can do that. The success rate of some lawyers might be high, as they filter out bad cases at the threshold and accumulate only good briefs. What's wrong with this? This is important. In my book, Lawyers, Glorified Priests or Empowered Judges, which is available as a Kindle edition online, I have explained these notions. The Honorable Mr. Justice M.N. Venkatachalaya, former Chief Justice of India, was gracious enough to write the foreword to my book. I am only extracting some portions of it to tell my audience that he also approved my rather unconventional notions. Here are the extracts from the foreword that he contributed. Quote, Sri Desai's first observation is that an increase in the judge's strength, though necessary, by itself is no assurance of quicker justice without a supplementary supporting procedural discipline. Sri Desai argues a system of private sector judges and observes, though there is a shortage of judges, quantitatively viewing, There is no dearth of lawyers in this country at the current level of litigation. Under ideal conditions, all diligent lawyers are meant to act as judges of the private sector only when there is predictability in judgments. It is the public as consumers who pay for their services without burdening the exchequer. If the subordinate judiciary in particular and the judiciary in general is predominantly predictable, diligent advocates can correctly advise their clients to enable them to arrive at settlements before trial. Only in a small percentage of cases, when the judges of the private sector are unable to come to a consensus, the state appointed judges step in to formally decide the dispute and give finality to it by acting as referees. In the US, the state appointed judges give formal judgments only in 2% of the cases, both civil and criminal. A vast majority of the cases are settled by the parties themselves on the basis of the concurring legal opinions. In other words, concurring judgments of lawyers on both the sides. Unquote. See, Desai speaks of the imperative of predictability and consistency in judicial outcomes and says it requires conscious human effort of lawyers and judges to make the judiciary predictable so that the citizenry can plan their transactions to avoid litigation and to win the cases when litigation is thrust upon them by the wrongdoers. Unfortunately, due to lack of predictability and consistency in judgments, we in India continue to visualize lawyers as priests in a temple who recite incantations before gods, that too man made gods called judges, and anxiously look to them to deliver either a boon or a curse. The appellate courts may reverse their judgments, but no punishment is being given to the wrongdoer as he is a judge. Though doctors, engineers, even lawyers and accountants could be hauled up in consumer courts or even criminal courts for their wrongdoing. The priests and the man-made gods of the justice delivery system have conveniently converted the litigants into devotees instead of according them their due and true status as consumers. Unquote. Sri Desai also comments some additional inputs to the Judicial Standards and Accountability Bill 2012 and says that accountability must also include an omission on the part of a judge to respect and follow a binding judicial precedent. If he fails to do so, he should be held guilty of misconduct and dereliction of duty. There are many other useful suggestions in Mr. Desai's agenda for speedy justice. I congratulate Sri Desai for the refreshing thought he has bestowed on a topic which has become banal, that is boring, by stereotyped approach so far. The public cynicism that loss delays have engendered might assume destructive proportions. Cynicism is a destructive emotion. Unquote. Now, this is how the former Chief Justice of India also has been impressed by these unconventional views. Law is predominantly like a railway track and not just a guideline. The mandatory provisions and binding precedents which interpret the law, forming the flesh and blood around the skeleton, are similar to railway tracks to bind the judicial train to travel only on the track. A lawyer, in his capacity as a railway map reader of the tracks, can guide the public to decide whether a track is available to reach the destination by train, and if so, which train is to be boarded and at what cost, and the probable time it might take to reach the destination. The directory provisions are like guidelines which can be crossed by the driver of a motor vehicle temporarily from the left track to the right track on the highway for the purpose of overtaking the vehicle in front and come back to the normal track on the left, that is in India, and on the right in the US, etc. That is why the Honorable Supreme Court has laid down the law that judge enjoys discretion only with regard to procedure, punishment, and costs of administration, and not with while deciding substantive rights. This was laid down in Uma Devi Nambiar versus Seethan dead, reported in AIR 2004 Supreme Court Weekly 1385. There is also another, yes. Precedents promote certainty in its absence, lawyers would not know how to advise their clients. This is reported in AIR 1990 Supreme Court 261. The name of the parties is Sundar Das, Sundar Jas Kanhayalal Bhatija Prahalad Hiranand Advani versus Collector Thane. No doubt, in the higher judiciary, predictability of judgments might become slightly less, as there is a possibility of a larger bench overruling smaller benches' ruling. The higher judiciary is like a railway track laying and repairing machine, which can be seen in the illustrative video. Such occasions arise rarely, but even here, if the higher judiciary applies the principle of prospective overruling of well established citations, it would go a long way in preserving predictability. Justice Oka Subbarao, a highly respected former Chief Justice of India, had applied this doctrine in some of his rulings, as he was acutely aware of the importance of predictability of judgments to guide the society in arranging their transactions. In recent times, this doctrine is applied in state of Manipur versus Suraj Kumar Okram, reported in Laws Supreme Court 2022 volume 2 volume 2 Supreme Court page 4. Otherwise, what should happen to the passengers who boarded a train from Chennai to Mumbai, and middle of the way the railway administration tells them that the track to Mumbai is removing the track which was already there when the journey commenced middle of the way, and judge overruling a binding citation, retrospectively are similar in operation and in effect. By reading down, reading into, and striking down enacted provisions, the higher judiciary is expected to repair the legal tracks or lay new tracks to enable the rest of the judiciary, including the unofficial judges called lawyers, to faithfully follow. The next point is how to deal with bad laws. No doubt, as Gandhiji had stated, just as there are bad men, there are also bad laws. The public have a right to peacefully protest against such laws when there is democracy. That is possible. If the government doesn't yield, in the next election, the public can let some other political party be elected by imposing a precondition that the perceived bad law should be repealed. The criteria to differentiate a bad law from a good law will be dealt with by me in another video with the proposed title Good and Bad Laws. I am yet to shoot that video. What I wish to stress is that neither a bureaucrat, nor a police officer, nor a judge have a right to ignore a law so long as it exists, whatever may be their personal opinions or gut feeling towards that law. Otherwise, the society will not be governed by the rule of law, but by the individual authorities, whether political or executive, and the poor citizen would be at their mercy. Rule of law was described by an eminent jurist as a leave to live without anybody's leave. It is for lawyers as social engineers to make this possible. Why are inquisitorial judges not allowed to pronounce judgments but submit only reports? This aspect was outlined by me in my video with the title Speedy Justice Part 1. Now I am going to elaborately explain the reasons for this limitation of inquisitorial judges' role to submitting only reports and enabling only adversarial judges acting as mere referees to pronounce judgments, deciding the rights and liabilities of the parties, though these adversarial judges are much lower in rank, like a magistrate or a sessions judge, when compared to a high court or Supreme Court judge, who usually heads a commission of inquiry and acts like an inquisitorial judge. Now I'm going to give the details. An inquisitorial or investigative judge is like a policeman entrusted with the task of catching a thief. Because of the compulsions to perform by catching the thief at any cost, the police may catch hold of some innocent passerby on the slightest suspicion and brand him a thief, if only to get himself relieved of the pressure to please the superiors by getting the results. This is called performance pressure. It is this pressure to perform that compels the police to extract confessions even from the innocent by third degree methods. That is why confessions before police are not admissible in evidence, while confessions before judicial magistrates are admissible. And not because the police are inherently bad and judges are inherently good or divine. This distinction, please note. To become an IPS officer is very difficult. So there are very talented persons who have become police officers, but still the law doesn't trust them. However highly placed he might be, let him be the Inspector General of Police. The reason is he has a performance pressure, whereas the judicial magistrate, he doesn't have such pressure, in the sense that whether the case ends in acquittal or a conviction, he cannot be blamed. He is only a referee. If it ends in a conviction, prosecution is to be blamed. If it ends in, if it ends in conviction, maybe defense was not satisfactory or it failed to establish its case properly. And if the case ends in acquittal, prosecution has failed to convince him. The magistrate is just a referee. He is not some divine entity far superior to the police officer. So this is very, very important. At the risk of repetition, I state that when a judge is appointed to head a commission of inquiry, he becomes an investigator. He can at the end only submit a report of his inquiry and not pronounce judgment, though he may be a judge of the Supreme Court. Though a sitting judge, while heading a commission of inquiry, is presumed to be free from pressures, he at least feels the pressure of justifying the crores of rupees spent on his commission to investigate and show that it is justified. And he might point an accusing finger on the slightest suspicion, though the said person placed in the dock by him might actually be innocent. In Telugu, we say కొండను తవ్వి ఎలుకను కూడా పట్టుకోలేకపోయాడు. So after spending crores of rupees on a commission of inquiry, if the judge reports, the Supreme Court judge, I am not able to find out who is guilty, therefore I am submitting the report, you close the commission. Then everybody says this judge is inefficient, he is not able to find out who the person who is guilty. Therefore, to show that the expenditure on him is justified, he might point an accusing finger. That's why he is only authorized to give a report and not pronounce judgment. And the judicial magistrate can pronounce judgment. That is the reason. If the magistrate, let all the magistrates, judicial magistrates note this, if the magistrate acts like an investigator by adopting inquisitorial approach, the purpose of trial is defeated, as there would be two investigations, one by the Supreme Court judge and another by the magistrate or sessions judge, and not an impartial trial. Judges in the adversarial courts should commence the proceedings like agnostics. The next reason, inquisitorial judges have a strong tendency to reach a conclusion at an early stage and to adhere to the conclusion in the face of conflicting considerations later evolved. In the language of the committee of the American Bar Association, what generally occurs in practice is that at some early stage, a familiar pattern will seem to emerge from the evidence, and it is waiting that for an accustomed label to be put, and without awaiting further proofs, this label is promptly assigned to it. It is a mistake to suppose that this premature cataloging must necessarily result from impatience, prejudice, or mental sloth. Often, it proceeds from a very understandable desire to bring the hearing into some order and some order and coherence. For without some tentative theory of the case, there is no standard of relevance by which testimony may be measured. This appears to be rather abstract. If you read it twice or thrice, you will understand. But what starts as a preliminary diagnosis designed to direct the inquiry will quickly and imperceptibly become a fixed conclusion, and all that confirms the diagnosis makes a strong imprint on the mind, while all that runs counter to it is received with diverted attention. An adversarial serial presentation seems the only effective means for combating this natural human tendency to judge too swiftly in terms of the familiar, that which is not yet fully known. I have extracted this from the book Law, that is the title of the book. It's a Voice of America lecture, page 102, quite an old book. The next point: inquisitorial judges are in general blissfully ignorant of the fact that truth is relative to the observer. They behave like bureaucrats in disguise. They mistrust the caliber or honesty of advocates and unnecessarily study the entire records of the proceeding, from the pleadings to evidence and all the documents themselves. All this adds to the delay in disposal of cases. A strictly adversarial judge should not read the record before hearing the arguments, even after the arguments are advanced. He should look into the records only to verify the disputed facts and not the whole record, and quickly pronounce judgment. That is the reason why Order 20, Rule 1, Civil Procedure Code enjoins that judgment shall be pronounced at once after the arguments are concluded. If he commits a grave mistake, there is a mechanism of review provided under Order 47 and Section 151 CPC. In my earlier video, Speedy Justice Part 1, I have already explained this in detail. And recently, fairly long ago, even the Supreme Court has considerably expanded the scope of review of judgments. Earlier, it was quite narrow. Only if there is an error apparent on the face of the record, a review can be entertained. But all that is now gone. A 5-judge bench of the Supreme Court has considerably widened it. It's something like a narrow road being turned into a national highway. So the object is to prevent clogging of courts in the appellate court and ensure quick justice in the lower court itself by reducing the expenditure and the time taken also, because after all the judge also knows what are the facts of the case. He has recently decided it. Both the advocates know. Just the arguments will be confined to the errors committed by the judge. And even the advocate, if an advocate mistakenly doesn't cite a point of law, say a binding precedent, that's also a ground for a review. That's what the Supreme Court has said. There is no need to rush to the superior courts and again file appeals, engage costly advocates, merrily go on enjoying at the cost of the party. Unfortunately, the Criminal Procedure Code doesn't contemplate any reviews. It is high time the higher judiciary reads into the CRPC or expands its scope by providing for such a thing, just as they invented in the Supreme Court what you call curative petitions. The word curative petition is not there in the Constitution, but justifiably the Honorable Supreme Court has expanded the scope of that. Rather, it has provided a new remedy when obvious injustice is done by a few judges. The curative petition is decided by the entire Supreme Court, something like that. Why not provide, when CPC can provide for review, why not a criminal case? So it is high time the Honorable Supreme Court looks into it. Of course, it is for the lawyers there to argue this point. I hope this video will convey this message to them. Inquisitorial attitude of judges when they preside over adversarial courts is not compatible with democratic ideals and dignity of the individual. An inquisitorial judge is apt to think, it is my responsibility to know the truth. I will know it by my own effort and initiative. I will dole out justice to you, the litigant. You meekly take whatever I give. Whereas an adversarial judge would not be so egoistic. His approach would be, I am only a referee in a match. The laws are already made by the legislature. You, the citizens, have entered into deals as per your understanding of those laws or as per the advice given by your lawyers who are like your coaches. You have approached me to enforce your rights as consumers. You are the first judges. Mind you, it is the citizen who is the first judge. It's not the lawyer, it's not the judge at all. You are the first judges in the sense that you first decide that you have been wronged and approach your lawyers to work out the details of your case. If the citizen doesn't decide to approach the lawyer, there is no question of any setting the ball into motion. So he first decides something wrong is done to me, I must see a lawyer. So he is the first judge. The lawyer gives, because he is a legal expert, he gives the professional details, the technical details. I am only an umpire. I am neither an embodiment of justice nor a source of justice. This is important. You have won your case as you have played the game as per the law of the land. I am only a certifying authority, subject to appeals and reviews, and when I commit gross violations knowingly, I am subject to disciplinary proceedings. Rule of law is described as leave to live without anybody's leave, which I have already quoted, which includes the leave of the judges too. This is the only way to empower the citizen instead of treating him as a humble recipient of benevolence of authorities, whether of the executive variety or the judicial clan. In any game, the players can play confidently with dignity and improve their standard if they are free to concentrate on the game instead of being at the mercy of the referee. This applies more to lawyers. For example, in most of the high courts, appeals are pending for nearly 15 to 16 years, whereas the law says, civil procedure court says, in 2 months they should be disposed of. Order 41, Rule 11A. Why lawyers are not questioning the judges there? Because if we question, judges may be offended. So why should we offend them? Why should we rub them on the wrong side? They may keep this in mind. They may hold against us. That may affect our practice. So this kind of attitude that is responsible for the delay. The disease is something, the diagnosis is something, the treatment is something else. That is what is happening in the judiciary now. All these lok adalats and all that. Of course, lok adalats are intended to actually persuade parties to compromise. But in my view, at least in my practice of 41 years, but lok adalats came into existence some 20 years ago. I have not seen a single case where at the time of entry into court, the parties were at loggerheads, and because of the effort of these members, they agreed. The Lok Adalat members, all cases which are already settled, they are posted on a particular day, and then the statistics is shown as if they are settled in Lok Adalat. Why they are doing it? Because there is pressure from the higher authorities. So, how many cases have you shown? Why don't you settle so many matters? How it is possible to settle? Therefore, the remedy is quite different because diagnosis itself is wrong. That's the problem. Then an inquisitorial judge is a glorified policeman. A policeman at least takes the trouble of visiting the scene of occurrence, catches the suspected criminal at considerable personal risk in nabbing him, whereas an inquisitorial judge attempts to play the policeman when comfortably seated in his court, air conditioned court. Inquisitorial judges take the litigating parties by surprise by coming forward with their own hypothesis, which is not put forth by either of the parties. By their propensity to take initiative, they encroach upon the jurisdiction of the executive and thus violate the principle of separation of powers. On the other hand, adversarial judges fairly reopen the arguments whenever a new point of law or fact occurs in their minds, give opportunities to both the counsel to argue on those points and then only give a decision. They never shock the parties by surprising them. They never hit their ships with torpedoes of their own equities or ideas of dharma. See, a torpedo, when there is war, a torpedo attack takes place by sending a torpedo. It's nothing but a bomb which travels below the surface and hits the ship. Suddenly, what happened? A ship has sunk. The same thing happens when the inquisitorial judge decides cases, sitting as an adversarial judge. No doubt, judges also can apply their personal knowledge of the law, but there is a method of doing it. First of all, they should confine their objections, if any, to inherent jurisdiction or question of jurisdiction, then question of court fees or question of limitation, because the law says even if the parties do not plead the bar of limitation, the judge should do that. So except these things, other things are left to the parties. But the nowadays these judges don't know about all these things. They're never told. So they go on acting like inquisitorial judges. A few important judgments of the Supreme Court. Now I am going to quote. A judge shall not decide an issue not raised by the parties expressly or by implication, and impose his own views. This is laid down in a decision reported in AIR 2000 Supreme Court Weekly 794. Gopalan Kutti Nair versus Kunhirama Tarakan. A judge shall not decide a new point of law or fact which is not argued by any of the contestants without drawing their attention to it by reopening the arguments. This is laid down in 2003 Supreme Court Weekly 4504. Union of India, Gopal Singh, Shambhu Dayal. Union of India versus Gopal Singh. Then, a judge shall not overlook a mandatory legal provision either during the conduct of the proceeding or in his judgment. Deliberate misinterpretation of law shall be deemed to be misconduct. AIR 1999 Supreme Court Weekly 2779. The name of the parties is Junjarao Bhikaji Nagarkar versus Union of India.